Hey guys, welcome to my channel. I guess I'm sticking to my old intro. It's just what I comes to my mind. Like, hey guys, what's up? Well, I guess it's more, hey guys, welcome to my channel. How are you guys? Okay, so this is going to be kind of a mix of things here. Well, it's going to be about the Clennney case, but I was just going to do the interviews. There's 2 interviews. They're really short, though. They're just audio. It's just basically, they're not like formal interviews. It's just, what's that noise? I heard like a vibration, but I wonder what that was from. Anyway, they're not formal interviews. I mean, they are by cops, but it's like, I guess I don't know where they are. To me, like, I'm picturing them like in the hotel, or not the hotel, the apartment complex lobby or something talking. But I have no idea. It doesn't seem like it's like a formal interview at the police station with the, the cameras and stuff. But it's 2 guys that are her neighbors that live in the apartment complex. And they're interviewed because they saw a couple things, between Courtney and Christian. So, like I said, they're really quick. I think together they're only like 10 minutes. So what I decided to do is I was watching the hearing from Thursday. I don't know if you guys watched it. It was yesterday, actually. I don't know when this video will go up. So it was Thursday. Basically, this video might not end up getting edited or being done edited and uploaded until Saturday. So, but anyway, regardless. So Thursday, I wish I would have remembered and I would have live streamed it. I found it quite interesting because I am into this case and I've been following it, and like I said, I basically did a deep dive. I would consider it a deep dive. I ordered the files, I read through all the documents and stuff, so I really am pretty invested in this case. So to me, the hearing was really interesting, so I'm going to play some highlights from it. So basically what it was is there's a few different things going on in the hearing. So number one, there's this TMZ like series documentary type thing that they are doing on this case, and I guess there's like a reenactment in it, and her lawyers are in it. Like, they, how in documentaries they'll have commentary or whatever. Well, they're in the documentary giving, like talking. Oh, real quick, I forgot to say, edit this in, it hasn't been released yet. It hasn't been publicized or whatever you call it yet, okay? So they were going to be in it. I think they say next month, maybe? I forget exactly when they said it's supposed to be aired, but it hasn't been aired yet. Okay, just wanted to make that quick comment. And so the state is requesting to stop that. They're like, we can't stop TMZ from making this documentary, but we could stop them, her lawyers, from being able to take part in it. So they're asking the judge, because they're like, you don't have jurisdiction over TMZ making the documentary, but you have jurisdiction over them, and they want her to stop them from being able to be in it, right? And they think they should be allowed. Number one. Number two, they do talk about a little bit about the new stuff going on, because it seems like these are the 2 lawyers that are named in the warrant for the parents in Courtney for the whole warrant, the third degree felony of them getting into Christian's laptop without authorization, basically. So they were the 2 lawyers that were named in that as taking part in the, conspiring or whatever. And you could tell that, they're worried. Like, she asks a couple times, like, wait, can you tell us that, like, our phones aren't being tapped, right? Like, because we have a job to do. We have to defend Courtney. We have like our defense planning and the texts, and like we want to know if our phones are being tapped now because of this. And so no, they aren't, but they're pretty worried about that, and then also worried about them going through too many of their texts. And in that group chat, they said, we do, like, our whole defense is in that group chat. Like, you can't, if they have access to it, that's not fair, basically. So she didn't really answer that. So I don't know. As far as the wiretapping, no, he said that their phones are not tapped. But as far as the text, that was kind of unclear. I think there's certain things, what they said is like certain things they're looking for, and it wouldn't be like anything that was confidential lawyer attorney-client privilege type stuff. But anyway, it's very interesting. There's a lot of tension in there. And so what I felt was kind of interesting is her lawyer talks about how the media they're only requesting like the juicy stuff, basically, like the interviews and body cams that paint her out to be like this monster. Not in so many words, but basically that's what he's saying. It's like, the stuff that's like the juicy stuff, they're only wanting this stuff, but they're not requesting some of these other interviews, which is kind of ironic, if that's the right word. Actually, it'd be the opposite of ironic. Because the 2 interviews that I've been meaning to upload would be kind of the ones that he's referring to, where it actually shows the other side, like where it's like, I don't want to say in her favor, I don't know how to word that right, but yeah, kind of in her favor, where just basically it's 2 guys that are basically see it as her being the victim, okay? So her lawyer is saying, the media doesn't want those ones, and they're just wanting the good stuff. My 2 last interviews that I haven't uploaded out of all of them are those 2, and I did not do that on purpose. I've been wanting to upload these for a while. I started uploading the Courtney Clennney stuff like right after the autopsy stuff, and then I just got sidetracked with another case. I didn't get them finished. Plus, I was like, you know what? I was kind of slowly getting them out. They weren't really getting good reception as far as like there really weren't people interested in the case that much. So I was like, you know what? I was like, maybe I'll slow down on uploading these. And I wasn't uploading them in any order, swear to God. It's like, but maybe I'll slow down in uploading them because until the trial, where people get, maybe where people are more interested in the case when the trial starts, and then people will be more interested in it. But then this stuff all came out with the parents and stuff, and people were talking about this case, so I'm like, I gotta just finish. I only have 2 interviews left. Well, actually I had 3. I had the interrogation that I just uploaded. I had that too that I hadn't uploaded, that I just uploaded like a week ago. So it was the interrogation and then the 2 short little interviews. And so I was like, you know what, let me just get them out so I could have everything out. So but that is interesting. He talks about that, like about people not uploading those kind of things. And it's very interesting because these 2 little short interviews are one of the things that I haven't seen any of the other news stations release. And if they did the like a records request, they would have got them just like I got them, unless if they specifically only asked for certain ones. So why didn't they? And then also that one, was it Vivian? I feel like there's one more that kind of looked at it like where the people were looking at her as the victim, which I'm not saying I think she is, but I'm just saying I'm the type that wants both sides out. I want to just whatever is out there and whatever that I could find, I just want it all out there so people could have like a good overview of everything and not just see one side. So, but that is interesting that I haven't seen these out there, and they would have had them too. So why did Long Crime choose to only upload like the elevator video or that new stuff that came out, or I'm just using them as an example on crime, but like any of the other ones too. So I mean, he's making a good point. Wonder why? Because I like to have everything out there. If I get it, it's like anything that's appropriate or that is important for the case. But yeah. So I'm going to play a couple clips from the hearing right now. Then I'll play the 2 interviews. And then I'll play more highlights, okay? I feel like they are kind of relevant because it's what I was just talking about, how her lawyer's going on about, like, how the media only wants to play certain interviews or show certain things. And right here, the one I'm going to start out with, I think he is talking about specifically, when they're talking about the 2 people from Canada, I think he is specifically talking about the 2 interviews I'm going to play on this part, because these 2 guys, the interviews that I'm going to play, are 2 guys from Canada. And they would fit the description of what they're talking about, of basically the defense wanting them as witnesses and stuff like that. Okay, I'll shut up so we can play.
The 2 witnesses listed yesterday have to be determined addresses in Canada, and then we have international issues in terms of setting them in service. That we'll cross that bridge, but I'm just...
I mean, at some point in time, you're going to have to make them available for deposition. I'm sure that they know that. And yeah, you can't send them a subpoena at TBD.
Yes.
And also, just so the court knows, is that these were individuals that were also interviewed by the police on the night of the incident, so the state is aware of them and has their recorded statements already in their
But
possession.
their addresses aren't listed in the warrant.
Correct. Judge, I can clarify that to the court. Our investigator attempted to speak with them again, and they had subsequently changed their phone numbers. But we do know that they reside in Canada, but at this point, I don't have their address. I don't have a contact number, but we will be obviously working on that. But again, the state has their statements that they make to the police, and I believe they're actually, I don't know if they're actually listed by the state already. They should have been, but so they're state witnesses as well.
Judge, I'm sorry, because we didn't get to address the second matter. The second matter is when witnesses are listed by the defense, there's no category application to the defense. Only category applications apply to the state. The state has an absolute right to depose all witnesses.
That's fine.
And that's where our issue becomes, is they might have been listed by us because we have an obligation to list all persons we know to have information. Once they list them, it triggers our right to depose them. And that is the equation here. And I do want to highlight one more issue before we move on to compelling, is that it's always on the eve of a motion before this court and a hearing in this court when we receive reciprocal discovery. That is a problem because the rule triggers 15 days. I absolutely appreciate that the 15-day period is when the defense decides that they're going to do that at trial. But that definition would swallow the entire rule if we decided yesterday, we decided this morning. And so I just want to make sure that everyone's aware about that. We can't just have...
I'm going to have to take them at their good faith statement that they are filing this in a timely way. It's within 15 days of the notice that they're going to list these as potential witnesses at trial. Okay? All right.
Okay, so pretty sure that these interviews are those two guys that they're talking about because they fit it exactly. The description, and they don't give their address in it. They just give their birthday and phone number, which she says they didn't give their address. They probably just forgot to ask, and then their phone numbers got changed. But, so yeah, I'm going to play you the two interviews, and then I'll be back with you after that to play some more highlights from this hearing.
Cars are with me, they're with me. And the black truck. Yeah, they're gonna follow me. They just have food in the car.
Okay, so today is Sunday, 17th of April, 2022. It's 4:45 p.m. And your first name is John?
Paul Salib, John Paul Salib, last name. S-A-L-I-B for Bob.
Okay. And your date of birth? Okay, what's your phone number? Okay, so I saw that there was a body cam that you were explaining an officer of an incident that happened previous.
Yeah.
So how long
Around a month ago.
About a month ago?
Yeah, maybe, like 3 weeks ago. I came home with my kids and there was blood on the outside of the elevator.
Okay.
And then they pressed the elevator button and it opened up and there was all this blood. So I went to the concierge and I said, what's going on? And he said a resident punched his girlfriend in the face.
Oh, okay.
The girl at the front desk. And then like even before, like the week before that incident happened, they were like parked at that building right there, the low rise, right next to like the highest part there.
Yeah.
There was a low rise and she was like trying to climb like out of the roof, like and he was trying to like climb over the car to like grab her.
Okay.
You could always tell like the demeanor like of the relationship, like you know, like I don't know.
When you heard about him punching her, where did you see the blood?
It was all in the elevator. It was almost as much as when that happened.
Really?
Yeah, it was bad.
Do you live on the same floor?
No, I live.
Okay. So but you guys use the same elevator?
Yeah, same elevator. Yeah.
Okay. But did they tell you that it was?
Can you tell him that he's gonna go wrong? Okay, cool. Yeah, sorry. No, he just doesn't speak English. Okay, cool. You explain to him in Spanish? Yeah. Okay, thank you. Sorry.
And did somebody tell you that that blood came from that apartment or?
No.
From that couple?
No.
Oh,
I asked the next day. Everyone talks.
Oh, okay.
You know what I mean?
So somebody told you that next day that it was from them?
Yeah.
Okay, and it was. Do you know their names or?
No.
No.
Like I seen on like line, like but like no.
But it's the same people that you.
Yeah. Same people.
Okay.
Yeah.
The blonde chick and the other guy.
Yeah.
And so when a week before the incident, you said you saw them down the street?
Yeah, at the low rise, like there, that like orange or yellow building there, and she was in her white Mercedes. I think it's like a C class.
Okay.
And she was like out of the sunroof, and he was like trying to like grab her like through the car.
Through the car? So he was sitting where, like in the passenger?
He wasn't sitting in the car. She was outside the car.
She was outside?
No, she was going like through the sunroof, and he was like going around, like trying to like grab her at different parts of the car.
Oh, okay.
Yeah.
And he was outside?
He was outside, yeah.
She was inside,
and the doors, I guess, were like locked because he was trying to open the door, and then I don't know, like why she was doing that, but he kept like trying to climb up and like grab her, and then she would go in.
Was he like yelling at her?
My windows were up, and I
did
just.
it seem like what was? It
was an aggressive manner. It wasn't like it was a game of hide and go seek.
Yeah.
Like,
Okay. And that was like what, like 7 days?
To go around, just drive around in a circle. That was
what,
like
like 7
less
days
than a week
before?
before it happened.
Okay.
Less than a week.
Okay.
And then the next day, after that incident, I was getting mail, and I seen a punch in the windshield.
Oh, you saw punches?
Yeah, there was a hole in the windshield of the car.
Okay.
Yeah. But like, you know, you could always like tell like, you could tell like when a girl's like being abused, you know, you could tell her demeanor. Like every time she would walk in with him, she wasn't even allowed to look up. She'd like stare at the floor. And like, I'm not biased. Like I don't know her, I don't know him. But I've seen situations and you can tell. And when he wasn't around, she's so like happy. Hi, how are you? When he was around, it's like she wasn't allowed to speak. Like you can tell when a girl's being abused. You know, like whatever people say, like it's bullshit. Like you could just read people's like expressions. And you could tell that the girl was fucking in a relationship. He was probably taking all her money from OnlyFans, because I guarantee you the guy didn't have a fucking job. Because every single time he got in the elevator, he reeked like weed. He looked fucking high. Like,
oh, really?
Yeah. Yeah, every time. She did too. But like, I'm sure they looked like they both were abusing like some sort of substance, whether it's weed or...
Did you ever witness any other incidents besides those?
No, my buddy saw, like, so I'll let him explain, but
okay. No. What's your first name?
We've only been here for like, we live in Toronto. We're only here for like, my kids are here till like doing this month semester.
Yeah.
And we're here from January 26th to July 26th. Then we go back to Toronto.
Okay.
So like, you know, like I don't live here like full time.
Yeah. Okay. What's your first name?
You guys are good?
Emmanuel.
Emmanuel, and your last name?
Paris.
Perez?
Paris. P-A-R-I-S.
P-A-R-I-S.
2 R's. Like Paris, France, with 2 R's. Yeah.
And your date of birth? And your phone number? Okay. So
what did I see?
Yeah, what have you seen between the two of them?
So altercation, one was going into the dog park, or I was in the dog park.
Okay.
And
how long before the incident was that?
Maybe 2.5 weeks.
Okay.
Yeah, 2.5 weeks. First time I met them was in the elevator going up. They came in on the 8th floor, so in the amenities, they looked like they just came from the gym. She was in fitness gear. She smiled and said hi. I said hi back to her. Then he came in the elevator right after that, and it was like just the weirdest kind of vibe between the two of them.
Yeah.
Not when it was just her. When he entered, he just turned around, and that's when he greeted me. He was looking at the digital display.
Okay.
And he was just like, hey, what's up, dog? It was just kind of awkward. Anyways, that was that. And now, whatever, it was probably like...
What was her demeanor that day as soon as he walked in? Because at first,
I'm gonna say partly like annoyed.
Like at first, when she said hi to you, she was different.
She was friendly. Yeah, she was friendly. But then when he came in, it was like she was close. Like she was close to me. He was like hugging the wall, like looking at the buttons. And the energy I got was like it was like either she was annoyed or she was afraid. There was something going on there between the two. Because as soon as I got back to the house, I actually mentioned it to him. I was like, yo, I just met this couple in the elevator. Something was off between them.
Yeah.
So anyways, now I'm at the dog park with Enzo, and I think they had 2 dogs with them, a white dog, I can't remember the color of the other one.
Yeah.
But I saw them advancing from Amara, and there was a crowd of people, and I was just looking in that direction, and I noticed her. And, you know, she saw me, I smiled and waved, and she didn't, like, she just smiled, that was it, didn't put her hands up. And she got close to the dog park. I thought she was coming in, and that's when he came up from behind her and he put his hands on her like that.
On like the bottom of her arms?
Like triceps.
Okay.
Like just above the elbow.
Yeah.
And then she turned around, and he did the same thing. He held her like that, and he started doing, like, he let her go, and he was doing this in her face, like if he was like pep talking her or something.
Yeah.
And she was looking at him, and then she.
So he was shaking his hands in front of her face.
Yeah, he was doing that. He was talking to her, and he was doing this. And
Was he talking to her like regular, or?
He wasn't yelling.
He wasn't
but
yelling.
it was like he was. I could tell like he didn't want anybody else hearing what he was saying. So he's doing this to her, and that's when I kind of like. I was thinking like, okay, if something goes down, there's enough people here that, and originally it was like she was paying attention. A couple seconds later, she did one of these. Like it was almost like again. So I tried watching, but I tried like just minding my own business. So I'm looking at Enzo, looking at them, and then eventually they just walked a few meters like towards the water, and then they walked back, and it looked like they came right back to the building.
Yeah.
And then I saw them after whatever happened with their vehicle. Did he tell you about that?
Yeah, he told me about the car.
Did he tell you about the windshield or anything?
Yeah, he saw.
Okay, yeah.
But did you see it?
I didn't see the windshield. I was actually, I just looked in the car because I was on the passenger side, and she was just looking down. And then, you know, before I even walked to be in front of the car, he was looking at me like that. So I was just like.
That was at the moment that you saw the punch in the windshield?
Yeah, that was. I actually didn't see the punch in the windshield.
No, but I'm saying like when you noticed it, they were in the car?
Yeah, they were in the car.
Oh, and she was looking downward?
Apparently that event happened over there.
Yeah.
I saw them when they were inside there. We were picking some stuff up from the delivery, like the mail room.
Okay.
So, yeah, I could just, it was just like something was up with them.
Yeah.
When I did see her in the elevator, the one thing I had to say is like, she definitely looked like she was strung out. Like, it looked like both of them, something was going on.
Yeah.
And that's probably the energy that I was feeling.
Okay.
So, like, she looked a bit worse for wear, like, skin-wise and stuff, and then same with him. You know?
Okay. Cool, man.
Yeah.
Oh, thank you very much.
Sure, probably didn't help too much, but...
Yeah. No, that's something.
Yeah. All right.
So what do you guys think? It's kind of different, you know, viewpoint on what they thought. See, I would like to know a little bit more details. Where did the guy from the apartment that works, what did he say, apartment manager or whatever, where did he get that Christian punched Courtney? Which I'm not saying that I don't believe that that could have happened, but I'm just curious, did the person see that happen, or did she tell him that happened? Because that'd be a something that I would want to know. Is it from what she said, or is it from something that he saw, the apartment manager? You know, that would be really important, because eyewitness, you saw it happen, or she said it. Let's say we find out that he saw it. I wouldn't be in like disbelief. I wouldn't be like, oh, no way. No, this very believable, in my opinion. Still could be her being the aggressor, you know, and her being the one that instigates it, starts it, but maybe in that 1 weak moment he reacted, or maybe in a few weak moments he reacted. Does that make it right? No. But does that make him in the wrong? Like in the bigger picture of things? And as far as what happened with her stabbing him, there's a big difference between punching somebody and stabbing somebody. But I guess it just depends on, as far as like how you're going to view the whole relationship. I don't know. It's a touchy one. I do think that there's a possibility that maybe they, you know, she broke him to a point where he ended up reacting, where most of the time it was her, but maybe there was some times where he broke him down, pushed, where he did end up having instances like that. So I don't know. What do you guys think? But I do think that, you know, it probably wouldn't be that weird or unheard of if they both got physical with each other. But with that being said, that does not mean that I am that I'm saying that she didn't murder him. You know what I'm saying? That she's not at fault. I'm not saying that. I think she is the aggressor. She probably, from my opinion, from what we've seen, it does seem like she's the one that instigated it. She was the aggressor. She pushed him. And he probably reacted a few times where it could even be one of these things. See, I was in a relationship where the person wanted me to hit her. Never did, but they wanted me to. They tried to get me to. They asked me to. They pushed me. Try. I didn't give in. Didn't have any desire because that's just not me. But like so it's like almost like they want you. I don't know if it's to make them feel better, but they like want you to hit them. Whether they say it, my person actually said it, hit me, or sometimes it might not even say that, but they do things to push because they want you to hit them back. So therefore they could have an excuse or blame you, or you know what I'm saying? So it's like they'll push, and then also because it can make them feel better. Like, well, it'll justify them hitting you, right? And then also, like I said, it's a thing they can blame you for, justification. Take the guilt off of themselves because, oh, he hit me, she hit me, So, but no, I don't think it's that weird that he possibly could have got pushed to his breaking point at times where she got him to respond and maybe hit her back. I'm not saying it's right. I'm saying in that toxic relationship, it's not that weird to think that happens sometimes, is all I'm saying. I'm not saying it always happens. There's just certain type of people. You know what I'm saying? Like, for me, there's no pushing. There's no breaking point for me to hit somebody. I break in different ways. I don't feel the need to hit or be violent. You know what I'm saying? So, but some people, they could be good people and not necessarily abusive people, but get pushed to their limit and get pushed to the fact by somebody aggressive and then, wouldn't otherwise do it, but is in a toxic relationship where the person pushes them to their breaking point where they will. But everybody's different, So I don't know if that happened with him. All I'm saying is it wouldn't be like that surprising, in a toxic relationship. You know what I'm saying? Either way, if we find out, no, that's not true, then that wouldn't be surprising either way, I don't know. So I don't know where the concierge got that information. I wish I knew if he saw it or she told him. So I'm not saying for sure. I'm just saying we have an account where the person said that happened. We have another account on the body cam where I think he is the concierge or somebody that works at the apartment complex. I don't know if it's the same guy this guy's talking about in the interview, but it was a guy that said that day where she calls the cops and the body cam, it's like the day before, he says that she gets out of the elevator and he charged at her almost like in a aggressive way, and the guard down there, security guard, had to grab him and stop him from going toward her. He's like, she charged at him. And then also, like, whatever this account is where he's saying he punched her, I don't know if the apartment person saw it or she just said it, but you have that. And then you have the guy talking about how he was seeing her in the car trying to climb out, and it looked like Christian was the one being more of the aggressive one. But I also do understand that the perception on that account, at least watching, I'm talking about his account of watching, I think he was watching from the balcony, right? And watching something happen in the car where he explains that. If he already has like a perception of where he thinks she's the victim and maybe, he's heard, he's punched her and whatever, he's already going to perceive that situation with him and her at the car in a different way. He's going to perceive it through the eyes of thinking Christian is the abuser and Courtney is the victim. So he's going to look at it and not at no fault to him. you know? But he's just going to look at it in a different way, already thinking that that's the way that it's going. So he might view it a little bit more like where it seems like Christian's being more aggressive and more the aggressor because he thinks that's what's going on, if that makes sense. Because for that instance, there wasn't anybody really punching or hitting anybody. So it would be just watching body language. You know what I'm saying? Now, as far as if the concierge saw Christian hit Courtney, you can't really mistake that, right? But I don't know if that happened. So, all right, so we're going to watch some more clips or highlights from that hearing because I think it's pretty interesting. Okay, so let's watch some more highlights from that hearing that was Thursday.
Yes, good morning, Judge Frank Padilla on behalf of Ms. Clennney.
Sabrina Puglisi and Diane Premis on behalf of Ms. Clennney.
And good morning, Your Honor. Tara Colas, appearing on the new case this morning. I'll be filing a notice of appearance later this afternoon.
Okay. Good morning. Good morning, Ms. All right, so we have two matters in front of us today, essentially two matters. One involves a motion to compel discovery, and the other involves a petition for order to show cause, as well as several replies back and forth.
And Your Honor, just for some housekeeping issues, if Your Honor wouldn't mind.
Sure.
At this time, in case F2214137, the state is filing an amended information. The defendant is still charged with second-degree murder with a weapon. We're adding another count of interception of wire, oral, or electronic communications, a third-degree felony.
You want to arraign her on the new amended information?
Can we see it? We've never
been notified of it. We've never seen it, which seems to be typical these days.
All right, nope, we're not going to have any of that here. If we're going to do any of the inappropriate comments or grandstanding, we're going to hold off on the hearing today.
Your Honor, while they look at that also, the state is also filing discovery for the court and handing over to defense a copy of the filing, as well as it's the warrants, Judge, that created the new case.
Judge, on behalf of Ms. Clennney, we're enter a plea of not guilty, demand discovery, and request trial by jury.
Okay, thank you.
It is making defendant A, Kim Dwayne Clennney, defendant B, Deborah Clennney, defendant C, Courtney Clennney. We're charging one count of offenses against computer users, third-degree felony, for all three defendants. We have provided a copy to defense.
On behalf of Ms. Courtney, we have not guilty, demand discovery, and ask that the case be set for trial.
Okay. And then for Ms. Deborah Clennney and Mr. Kim Clennney, who's representing them?
Your Honor, Kim Clennney and Deborah Clennney were arrested day before yesterday in Austin, Texas. They were subsequently released. They will be appearing in Miami at some point to self-surrender at TGK. There's a $5,000 bond, so those bonds will be paid and they should be released, is the messages I'm receiving. But as of yet, we do not have counsel for them. Due to the nature and circumstances of what the state's allegations are, I don't think that myself or Ms. Puglisi can represent them. So we will get them counsel.
Does Your Honor want to set an arraignment date so that...
Well, I think that we need to set it for them to have attorneys and for us to make sure that they are represented. So I'm going to go ahead and set this as I would another case and set it for 2 weeks for court-rate attorney for them to come in with counsel. They don't have to be here as long as the counsel's filed a notice of appearance. That's fine. We'll do it the same as we would any other case. So 2 weeks for F24.
2015 A, B, and C.
A, B, and C.
Yeah.
The defendant's attorney walked a very fine line several times, as we outlined. There was this court's hearing on the Arthur hearing where he made inappropriate remarks, the state objected, the court sustained. Then several interviews, remarks the state would not have, suggested make people fine. The respondent walked up to the line when he called the victim, who's deceased, is unable to defend himself, an animal. And there's a particular history that comes with humanizing people, and the pink elephant in the room is the racial disparity. That cannot be ignored. But the state nonetheless restrained itself. That crossed the line, the respondent crossed the line, when he gratuitously, and I don't know if the court has reviewed the video, but it's been available for the court, not a response to a question, not prompted, for no other reason, just volunteered that the victim was sexually battered by a family member. That's not appropriate. That achieves no goal. It is not asserting the innocence of his client. It is not saying the evidence will show that his client is not guilty. It is not saying when the case will be heard next. It's not discussing what preliminary or procedural matters might come up. That was, for lack of a better term, a cheap shot. That was wrong. And that crossed the line. The state is then left with the remedies, or the following options. Do nothing and embolden the behavior that has been progressing and escalating. File a petition to show cause, not calendar it. Contact counsel and say, please, stop. File a petition to show cause and calendar it, or move for a protective order and a restraining order against counsels and the litigants from making public comment. The state took its least restrictive means, and again out of professional courtesy, filed the petition because it needs to be a matter of record, sent it to counsel, emailed counsel saying we are not calendaring the matter. We hope the conduct in the petition ceases. 3 months later, the respondent chose to reply and bring up the matter with the court. So the state, candidly, has not sought a remedy on this matter. Frankly, as far as the state was concerned, because there was also no reply to the state's communication, we thought that it was water under the bridge. And we're here litigating this matter because the respondent chose to. To skip ahead regarding our reply, since the state's petition to show cause, and the state has not amended its petition to show cause or filed a subsequent petition to show cause, the respondent has arguably engaged in further conduct that is further escalating and raising the temperature that requires this court's attention. Again, we discovered this knife throwing not from court pleadings, this knife throwing expert, but from counsels on TV. We discovered that there would be a reenactment video, not from counsels, and there was email communications by the state with counsels during that time regarding the discovery, but from the respondent's co-counsel the day before Thanksgiving going on TV. That is not a way to litigate this case. We then spent, and I outlined in the motion to compel, almost 30 days berating the defense via email to provide us discovery because we did not want to delay the proceedings. We want to review whatever the materials are, decide our strategy, conduct our discovery, and litigate the case. It's been 17 months roughly since the defendant's been arrested. April 3rd, 2024 will be 2 years since Christian was killed. And it feels as this case is moving at a snail's pace. So to put it bluntly, we want to get it down to brass tacks, and litigating these collateral matters are not in the state's interest. And it's especially the state has not sought to address this matter. So the respondent wishing to take up this court's time with that matter rather than getting to the discovery. And frankly, the statements that have been made in the last 48 hours are just increasing that temperature. And if counsel wishes to litigate and get an order from this court, the state welcomes it. We will comply perfectly with an order if this court were to craft one. With the Toledo, we provided the court a draft of that order that was affirmed on appeal. The state has no public statements to make about this case. We want to try it. We want to try the defendant and her co-defendants as expeditiously as possible.
In your response, you had also mentioned, and I also happen to see the fact that, and I don't know whether you want to address it, but like, if you're going to free to go ahead and do it now, the fact that there is some sort of docuseries or TV show in the making prior to the trial in this case, where the officers and the witnesses are allegedly, interviews are being sought from everybody. I had also seen it online.
Yes.
And was very surprised to see that.
I can address that. So the state has not ever been approached regarding from TMZ regarding our comment and participation in this docuseries. We learned about it almost contemporaneously with one another. We served a subpoena on the defendant's management company for behind-the-scenes information, contract, etc., premised off of the respondent's statement that she was allegedly human trafficked. So we expect that might come up in trial, so we might have to rebut that.
Human what? Who? I am so confused. There's a lot that's going on that either I'm just not aware of or it hasn't hit the media yet, and that's what they're trying to talk about. So he's talking about this TMZ, right? This documentary, and that her lawyers talk about them being human, or that Courtney was human, or like human in relation to Courtney. I mean, am I understanding that right? Wow. So that's news to me, but I mean, I guess because it hasn't been aired yet, that would have been aired, and it would, well, I don't know, she might put a stop to their interviews. Like she said, she can't stop what TMZ puts out, but she could stop the lawyers from being able to participate in it. So they already did the interviews, but she could basically put a gag order or whatever you call it, where, hey, no, that's not allowed to be in your documentary. Take it out. You can't have it in. But he's saying that they already did like little teasers where it released some stuff, but wow. Okay. That's interesting. So she's trying to claim her defense. What is she trying to say, that Christian was human or something because of the OnlyFans stuff, or is she trying to twist it like that? I mean, I guess I gotta keep my mind open. We gotta keep open. We can't, we gotta listen to everything fairly. So I guess until we hear that and hear the whole evidence behind that, I won't judge until I hear everything. But wow, it's the first I've ever heard of it.
The counsel for that company informed us that they were approached by TMZ regarding a docuseries that they wanted to interview his client. At roughly the same time, and the court has the emails in our exhibits, the City of Miami's public information officer received a request from TMZ to interview the lead detective by a person named Brian Andrews. He's a former local newscaster and the president of a PR company. We didn't want to blow up anyone's Christmas and New Year's, so Mr. Abeloff emailed the respondent and his counsels requesting this, whether they were participating in this because it's appropriate. And 30 hours or so later, we get a response, essentially neither accepting or denying anything. And about 10 days later, we find out from Lexington Capital that on that date, the respondent sat with the defendant's co-defendants for interviews. And there's actually a few matters that came to my attention after the state's reply yesterday. TMZ aired parts of those interviews already as a apparent teaser. The damage has been done. There's nothing for the state or the court could have done, but it further reflects and impacts the perspectives and nature of this litigation. And the state wanted to take another step on this too, because again, it was brought to my attention yesterday, in part because the reply was being drafted and matters have been developing. TMZ, I believe, was the first to report the arrest of Mr. and Mrs. Clennney. And that reporting stated that they were arrested for tampering with evidence. Clearly, the arrest warrant doesn't state that. Clearly, the facts in the arrest warrant don't state that. Clearly, the state's information that was filed and sealed at the time didn't state that. That was not a correct reporting. and the state has concerns about the communication based on an inference of whatever was told to the Clenneys on scene, because they weren't told of their charges because they refused to speak to the officers. So, given the intimate personal relationship the respondent's been having with TMZ regarding this docuseries, the state has obvious concerns that there's essentially going to be something televised, and particularly the state's concern, because it was alleged by the emails, is that this is being telegraphed from a particular perspective, and the state does not get to air an infomercial of the defendant's guilt before trial, so the defendant should not be either, and that's inappropriate conduct that the court should be aware to.
Judge, I can only say that the family...
Judge, I object to Mr. Hanfield addressing the court for this particular motion. He's a victim advocate under Marcy's law. They have no standing to address the court for this particular motion.
So the next clip I'm going to play is him telling the judge why he thinks, it's okay for him to be in this documentary with TMZ. And because basically he keeps talking about that the state let the toothpaste out of the tube because they released all this stuff. So Florida's the Sunshine State, so they have they're very transparent. So us media, we can request certain things easier from states like that are very transparent. They let us see a lot of the stuff. Unlike some states like Indiana, well, Carroll County, just the whole Delphi thing. Oh. But anyway, or even Idaho. It's the Koberger case. But anyway, my point is he's trying to blame, well, not blame, but he's trying to say, well, they let it out of the bag. They released all this information, the discovery. So why, and it's all one-sided, and it's all blaming, or it's all making Courtney look bad, basically, is what he's insinuating. So he's like, we're kind of in a situation where we have to fight back. We have to get our side. We have to give our side some attention, some media attention, because the way that this case is portrayed, it's so one-sided, and he's like, we should be able to have our side, is what he's saying. And the state's like, wait a minute, we're not pushing any narratives. What we're releasing are just the evidence. It's just the stuff that's in the discovery. It's the interviews. We're not controlling that. We have no narrative. We're just releasing the stuff that's in the discovery, And so he even points it out, calls them out, wait, you have to make sure your side, I forget the words he uses, you'll see though, I don't remember which clip it's in, but it's wait, you are saying that you have to get your side out, or there's no side, you know what I'm saying? We're not trying to do that with the media. You shouldn't be. That's what the trial's for, So the fact that he's like, no, we have every right to do this documentary because we have to, almost like he's fighting it back in the media, where the state's like, no, you can't do that, because he's looking at the discovery release and the the interviews and videos that have been released. He's looking at it the state trying to control that narrative and try to fight the case in the media, right? The public opinion, I should say. And so I do see both sides, but I do see the states wait, we're not just doing any side. We're just releasing what legally we have to, the files and the interviews and stuff. So I do get that, but I also get how the defense is this is crazy because everything that's being released is making my client look bad. But there's probably a reason for that. There's probably a reason that the discovery and most of the interviews is making his client look bad, because maybe his client's at fault. Maybe because most of the evidence in the videos shows what a lot of the times happens is that she's the one going crazy and acting like an idiot and being aggressive and at fault, right? Now, I know that there's going to be times where he could start things, right? Of course. We're human. I'm sure it's not always her starting stuff, but the bigger picture, it's probably her at fault. So most of the stuff they have is going to show that, right? Now, like I said, I guess it does depend on who's filming. So the times that people start filming, whether it be her or him, who's most likely to get a camera out and film when they're arguing, okay? And when. So obviously, whoever is filming is knowing they're filming, so they know to act a certain way, right? So is it always him that chooses, that has like the idea, oh, let's film this? Does she ever? Is there any videos of her filming where she wants to show something? Is he always filming because she's always going nuts and he wants to catch it? Or is he choosing to press play and film those, and then he knows it's filming, so he acts a certain way? I mean, we don't know. I mean, we only have what we've seen as far as those arguments are him recording the arguments. So it is kind of one-sided when it comes to that. Besides the elevator though, the elevator one. So, and I thought of another one, the last one that just came out, the one where I don't know who's filming. It's probably one of their friends. You could see like his leg or her leg. I don't even know if it's a boy or girl, but the most recent one that came out with them arguing. So never mind. That was like an outside party. Okay, I just remembered the latest one, so I just wanted to say that. Now, this is me editing, so I will go back to whatever was just playing. Yeah, so that, and then there's that one where you could hear the audio from the apartment. So yeah, there are a couple instances where it's not him filming. So it's just interesting. I know it's not going to, even with those, it doesn't tell a whole story. We're never going to know the whole story because it's not all filmed, and it does look like he's the one that's usually filming. I guess we'll see when the trial comes if she's ever pressed play. But then those would be biased too, because she would be the one recording. She knows it's recording, so she's going to act a certain way, right? So he's just like, that's a little tricky. And that's why the elevator video is very important. Because neither of them are even remembering, probably, because neither of them purposely hit record on their phone, so was aware, okay, I'm recording this for a reason. That's just like, I'm sure they know there's cameras in the elevator, but they probably weren't even thinking, because nobody sit there and hit record, so that's a really good piece of evidence. So yeah, I just wanted to set this up, and I'm rambling off, but yeah, so he's talking about, he just doesn't think it's fair, but like I said, that's the laws. They have to release the stuff, so whatever's in them, they release, right? And if most of them makes his client look bad, there's a reason for that, All right, I'll let you listen to it. Then, you know what? I wonder if I could hook a, I could do a poll under a video, because I would love, after you watch it, I would love to see if you guys think that, well, put it in the comments after we watch this, if you think that they should be allowed to be in the documentary, her lawyers. So it'd be before the trial. The TMZ documentary. Okay, let me press play.
Mr. Hanfield, right now I want to hear from the defense. You were the one who calendared this to bring it to, I guess, my attention. It hadn't been brought to my attention before. But given everything that has been going on, particularly the possibility of a docuseries prior to trial, I think that we should be addressing it. For whatever reason you brought it to my attention, the state hadn't brought it to my attention, it hadn't been documented, you documented it, so let's discuss it. What is it that you believe is appropriate about what you have been doing with the media, and why is it that you believe that you should be allowed to continue to do that?
Sure, Judge. And first of all, I'd like to say that I'm not sure a petition for order to show cause is the proper avenue. I think a motion seeking some type of protective order is more appropriate, but procedurally, the court can address it however it would like.
It's the first time that it's ever been in front of me on any sort of petition on any of my cases to address this issue, so I'm not sure what the appropriate avenue is, but we're here to see whether or not there needs to be a full response or remedy.
Correct. And Judge, I brought this to the court's attention by calendaring it because this was already filed. It was filed by the state. And what happens once it's filed, based upon the media attention that this case is receiving, the media, either through public records requests or now finally the clerk has finally got us like electronic access to the documents that are filed, it's open to the public. And in that particular petition, quite honestly, there's comments in it that besmirch my reputation. and I'm not going to sit by idly while I'm attacked by the state. And with regards to inappropriate comments that I made at the Arthur hearing to the lead detective, I'm going to rely on my written response. I'm not going to dignify it with a reply, verbally.
And I don't think that that's the bigger issue here at this point, so.
Sure. And the state saying that they had to barrage us with emails for 30 days, if Your Honor recalls, that's the time my father passed, and I'm sorry I didn't get it to them faster. But we're working this case, we've taken lots of depositions, but this particular petition filed by the state, I believe, needs to be addressed. Because we are constantly, from the defense side, being barraged by the media from day one. And, the state saying they can't unring the bell. Well, you can't put the toothpaste back in the tube either. And that is why at the onset of this case, I sought a protective order to limit the discovery being released under Chapter 119 because I knew this was going to happen. The state aligned themselves with the Miami Herald and fought me on that. All I wanted to have, and Your Honor was not sitting in this court at the time, but all I was seeking was an ability for the court to review discovery prior to it being released under Chapter 119. Not a complete gag order at all. Because the writing was on the wall. My office probably received 15 calls as soon as the arrest was made. I wanted to limit this, and now the state can't have it both ways. It's the pot calling the kettle. They know under Chapter 119, when they fought the initial disclosure of discovery, that this was going to be a subject of great media attention, and they were happy to list all the items in discovery in detail, and then began the onslaught of Chapter 119 requests made upon the state to get all the video. To take it back, when Ms. Clennney was arrested,
Onslaught from defense or onslaught from media?
Media. Judge, a very carefully crafted press conference was done. Ms. Rundle's been in office, I think, over 30 years. She was my boss. She was, I think, your boss at some point. They're a very sophisticated state attorney's agency, I think the second or third largest in the country. They have a public information officer. They knew when that discovery was released that they were going to receive tons of requests for the videos, the audios, which are subject to suppression, but that's a motion for another day. But they knew it was going to be released, and they know that every time a media agency makes a Chapter 119, they're going to throw their hands up and say, well, we have to comply with the Sunshine State laws under Chapter 119. We're not giving it to the media. But they knew that from the beginning that would happen, and now they're hiding behind that to say it's the defense that is putting all these things out there. They let the toothpaste out of the tube, and we're trying to put the cap on it. Why? For example, the video released at the press conference of Ms. Rundle standing there going like this, we take issue with that. We don't think the facts support that. The elevator video was released because why? It's great for the state. The media is going to love it. But they don't supply it with context, which is the danger that the state was facing by listing all the discovery and media outlets picking pieces of, oh, send me this video, send me that statement, send me this interview. Nobody wants to request the body-worn camera of the defense witness Arthur Cupp saying that she saw Obamseli beating Courtney. Nobody advertises that. No media outlets are covering that for the defense. The state's not putting that out there either. As an obligation to defend my client, the rules allow for...
And that's true. At least from the request that I did, they didn't send me that, though. I mean, they didn't send me that specific body cam. Why is that? I don't know. It's interesting. They did send me those 2 interviews that we listened to, though. Okay.
Need to give pushback, to characterize the evidence, to make sure that my client gets a just and fair trial. We're not trying to impede justice. We're trying to make sure justice is done by showing when the media contacts us, hey, do you have a comment about the new video? It's not new. It's just they found it because the state released it. or the Hackett Law Firm, with Mr. Hanfield and counsel for the estate of Ogunselli, release another video. And then the onslaught begins. Mr. Prieto, Ms. Puglisi, do you have a comment about this new video? And in order to protect my client's right to a fair trial, I have to. I am ethically obligated to push back against the narrative that the state began to spin in August of 2022 when they had the press conference. Then again, when they fought the defense on a protective order, saying, no, we want all the discovery out there. Now they're complaining about the discovery that they released. The text messages that unfortunately show Mr. Ogunselli was a victim of a sexual battery are in the text messages they made public. This is evidence that was provided to us, it was provided to the media. And now they're complaining that it's being released and that I have to comment because things are being taken out of context. All the media coverage to date has been vilifying my client under narratives that we have an opinion of the evidence that takes a different take, that is supported by the evidence that the state produced to us. And we have an obligation to make sure that our client gets a fair trial.
Judge, if I may just add something. It appears from what Mr. Quinnen said that they're not trying to prevent us from speaking to the media. I think that's what I heard him say. We obviously have a First Amendment obligation, just like the media has a First Amendment right to report. We are not trying to waste time in this case. Our client is in custody for almost 2 years. We want her to get to trial as soon as possible, but it makes it very difficult. This is not your normal case. With media attention, it unfortunately brings us having to respond to things. And one thing that I think is a perfect example of that, Mr. Quinnen mentioned that recently, within the last 48 hours, there's been news media coverage about the Clenneys being arrested, and one of the things talked about tampering with evidence. And he himself just now said on the record, which I'm very happy for, about the fact that this is not a tampering case. There's no evidence of it. But you know what's going on in the media is that Mr. Prieto and I are being vilified as being said that we are instigating this and we had our clients alter the computer. That's what's out there. Imagine now we have to try to defend ourselves from what's going on. So we can't control what the media says, but as he said, we have to be able to respond. And so, you know, we have a motion to compel, which I know we just filed it last night based upon what's going on in the new thing. You probably don't, and they haven't had a chance to respond. We're going to ask you to try to put it on as soon as possible next week, because our whole text communications were reviewed, and it is our whole defense laid out in the text communications, which were subject to this new charge. That's how the whole case started with this new offense. It's based upon reading work product that we had. And so now I don't know who had read the text from there. We're going to ask the court to do a protective order because God forbid that discovery comes out and now they can Chapter 119 request all of our text messages. But there's a lot of issues to deal with. As you can see, it's not your normal case. So we are just making sure we calendared this only to make sure that we're not being prevented from being able to vigorously defend our client. It appears that Mr. Quinnen is saying he's not preventing it, so I think there may be no issues.
Okay, let's...
Can I address one of the concerns the court had?
Sure.
Well,
might have been where I was going anyway, but go ahead.
Yeah, so the docu-series, I can tell the court, yes, we were approached and interviews were had. We were approached because somebody wanted to put a neutral message out there to get both sides, not just let's call it the crazy elevator video side. They contacted us to put out a neutral documentary about what the family perceives is going on here and the evidence that the state already put out in the public. There's nothing there that the state didn't already put out through their They're complete.
Choose your words carefully.
Yes, Judge. They put everything on the table, and it was a buffet for the media. And that buffet is still it's stacked with food, a never-ending supply of food. Another video produced by the civil attorneys, who, by the way, were on Court TV this morning, talking about defense counsel, talking about the video they released, I think, a week and a half ago. So, Judge, in my response, I cited the rules of professional responsibility. The model rule talks about this type of thing, that I am entitled to push back against the narrative that has been put out there. And I'm not saying the state is the ones telling the media, hey, have this narrative. But they're getting information piecemeal, as Ms. Puglisi says, these little snippets in time. And they are going to characterize them, demonize them, not the state, the media, as however they see fit, that creates the clicks on the websites, that creates more media attention. I believe the rules allow, number one, the freedom of speech is obviously something that's implicated here, but more so to make sure my client gets the fair and impartial jury and trial. So
Let me do this.
Sure.
I want to take it back to what the standard is. So I don't know that either of you are asking anything particular of the court. Maybe a protective order. It sounds like you had already asked for a protective order. Maybe you're asking for one now. The standard here, again, is whether or not any extrajudicial statements are substantially likely to materially prejudice the trial, which I think I hear from both parties. We want to have a fair trial. Obviously, that's the goal of all of this, is to have a fair trial. And how do we do that in the presence of such media scrutiny?
I really like this judge. I really do. She seems very fair so far, We'll see at the trial, but it just seems like she's really listening and sympathizing with what everybody's saying. You know what I'm saying? And it's like, I don't know. She seems, I think I'm going to like her. Okay, so I'm kind of just skipping around because I have highlighted parts that I'm going to play. I'm not going to play the whole thing, but...
Are you both suggesting, or are neither of you suggesting, that we should somehow tailor this so that both sides are prevented from giving more media, attention or discovery? I just want to hear what it is that you guys are suggesting to me, because I hear from you that you were worried about this from the beginning and that you're worried about the media's response to the discovery that's been put out there. I hear you guys saying that you are worried about what defense is saying in the media about their case, about the victim in the case, and potentially whatever this docuseries is or will be. So what are you both suggesting and requesting from the court? I'm going to hear from the state person, and I'd like to hear from the defense.
Yes, Judge. So, regarding the respondent and the defendant's motion for protective order, the state actually believes the court should tailor. I think it's at the juncture where the court needs to tailor some kind of order over the parties. To the protective order that the defendant filed, the issue with that order, and the court well knows, the state's role is to function as a minister of justice, and we could not go along with that as much as we'd love to. Limit our office because it's drained our resources. Our PIOs contact us to direct them to our evidence and discuss what's in our evidence. And that takes away from our time litigating this case and other cases as well as investigations. As much as we might love to do that, we cannot lawfully stand in this court and be like, yeah, Judge, seal all the discovery. We cannot. And that was our position then, it's our position now, and it will be our position always. And even if we had gone along with the defense's petition, Miami Health would have appealed it, they would have won, and we'd be back at square.
I understand that that wasn't what they were asking, but...
They were asking the court to in-camera micromanage discovery. That was their injunction. And that discovery was subject to public records. So it was the court superseding Chapter 119, which was the state's issue. There are collateral issues, but nonetheless. Handling the case in Florida as opposed to federal court has has, for a litany of cases, presented as challenges because we are the Sunshine State, and sunshine is the best disinfectant. And so we, the state of Florida, and as a prosecutor in the state of Florida, we believe in the Fourth Estate and their right to scrutinize us, scrutinize the defense, scrutinize laws enforcement, and scrutinize our case. We welcome that, and that's perfectly okay. The problem becomes, counsel gets a call. What do you have to say about this new video that was released by the attorneys for the family? No comment is easier than going on TV. Or, my client is innocent, we'll prove it at trial, no comment. Or the evidence will show my client is innocent. It does not necessitate outing a victim of sexual battery on television. It does not necessitate that. And certainly it's available in discovery, and certainly it's subject to public records. And just like the respondent leaked to a local news station regarding body camera from 48 hours before Christian's murder, and then gave an exclusive interview, frankly, that's subject to that too. We can't do anything about that. And the TMZ special, that bell is wrong. We can't do anything about that. The court does not have authority. And again, this is as a minister of justice and a prosecutor. The court cannot preclude TMZ from airing whatever footage they had. And that's where counsel's inappropriate actions require attention from this court. And that's why it's a petition to show cause in this form from the state, because his professional judgment, mind you, Your Honor, I've been an attorney for 7 years. I went straight to violent crimes, and I've been doing this for quite a long time. But counsel's been an attorney for over 20. And he well knows, especially his time as a prosecutor, and he well knows that he should have precluded that. As a matter of fact, the victim's family precluded the TMZ interviews and specials. The victim's family was also approached, and they turned down interviews and interaction with TMZ.
All right, so what is it that you're requesting at this point now?
Your Honor, I subject all the parties to no public statements unless it's procedural. And the state would gladly abide. And I can't speak for counsel for the civil case. I don't know the court's jurisdiction. I don't know if the respondent represents the defendant in the civil case, but a similar remedy could be sought in the civil case.
That's the problem, though, judges, is you can't preclude the civil lawyers, you can't preclude the media from speaking. You know, the train has left the station, and it's now too late for us to prevent that. I mean, I'm not really going to get into much about the outing the victim as a, sexual victim. It was taken out of context. We've explained it. There was no intent to try to shame anybody here. But we can't simply say, no comment, we're taking our client to trial, we think she's innocent, because that's just not good enough. It doesn't stop the media from continually, every single day this is on TV, on court TV, they're constantly reporting on it. And so we have to be able to speak up at this point and respond. Now, I understand that those comments need to be ethically made and done professionally, but we can't be prevented, or we should not be prevented from making comments at this time, because it's not just, and I'm not saying the state makes comments, because they don't, it doesn't come from them. It comes from others. And unfortunately, I don't think the court can stop that happening. And until the court does have that jurisdiction to stop the media from actually speaking, then I don't think we have any remedy.
May make one comment. But the issue here is we're also still before a lot of different evidentiary motions. There's going to be a lot of things that may be allowed in, that may not. The problem is when comments are being made about things that will not be coming into the trial, there may be jurors who are listening to these interviews. They're going to hear this and then look and expect it. And that's the problem.
Yeah, this is the issue that I have about the issue of materially prejudicing, they're being material prejudice to us getting a fair trial. Some things I think, no, it's not an issue. A lot of the stuff, things at the ARC hearing, those have nothing to do with us getting a fair trial. The issue becomes when you're having a docuseries where you are allegedly putting forward, purported evidence and witness statements prior to us getting to any of these evidentiary hearings or getting to trial, I think that you come a lot closer to the standard. And I think that you do come a lot closer to potentially prejudicing a fair trial. And that's what I want to prevent. That is my jurisdiction, is to make sure that I am doing what I can to make sure that Ms. Clennney has a fair trial, to make sure that the state has a fair trial, and to make sure that it hasn't completely been tried in the court of public opinion before we get here with a lot of evidence out there that's not going to be necessarily evidence that comes in either at the evidentiary hearings or at trial. So that is my concern.
But what happens with the discovery that is already in the possession of the media through Chapter 119 that won't necessarily be admissible in trial? Because we all know there's a lot of evidence that doesn't actually get admitted, but they are already showing those things in the media, and so those people you're talking about are seeing those things.
I think that those are, listen, I'm not saying that you're wrong about it being unfortunate fortunate or unfortunate, the reality is that we are a sunshine law state, and that we do have a very wide, there's very wide latitude given to what people can request with regard to the discovery in this case. What I can prevent on that or not, I don't know that I can. I think that that's something separate. But again, I agree with you that all of that's been taken by the media, and that everybody knows, everybody across the world, I think, if they're interested, knows, what the potential discovery is in this case. But the question is there anything that needs to happen now, given the fact that we do have that wide latitude with our sunshine laws, to try to make sure that we are doing as much as we can to make sure that we are going to have a fair trial. And whether or not comments on either side, or whether further interviews, which aren't subject to a sunshine law, the interviews don't have anything to do with sunshine law. They don't have anything to do with the ability of the public to get the evidence in the case, to get the discovery. That's not sunshine law. That is something that I do have jurisdiction.
That's First Amendment, though, Judge.
Some
That's
of it is.
what it is.
But all the case law has to do with, how the First Amendment abuts narrowly tailoring any sort of restrictions on the First Amendment. You absolutely do have, First Amendment rights, and I think that there has been a lot of case law that has struck down restrictions on that First Amendment right. But there has also been case law that has upheld that when it is narrowly tailored and when it's done correctly to preserve the fairness of your defendant's right to a fair trial and the state's right to a fair trial. So that's what I want to hear from you, is why it is that you believe that you should be able to, do this docu-series, that you should be able to make all these comments, and why you believe that that is not going to materially prejudice the trial in this case.
Judge, again, the state let the toothpaste out of the tube. It cannot be stuffed back in by Your Honor, by myself, or the state now, perhaps in hindsight, could have had a filter team going through discovery, and yes, it would have been more work for everyone, but that would have prevented it. But that's water under the bridge. At this stage, I'm asking the court to take no action on this petition, deny it outright, because we have to, when more discovery comes out, we have to have the ability to push back. So, for example, Court TV calls us almost twice a week, and we don't go on very often. When we do go on, it's because they had a panel of experts analyzing video and commenting about what these quote-unquote experts think the video shows. And that is improper for us to remain silent about. For example, the elevator video. Nobody talks about how that elevator video, the elevator goes directly into the client's apartment. Nobody talks about this gentleman having the only fob. And if we are not able to push back at the level that we've been pushing back against the media mischaracterizing the state's discovery, that will materially prejudice our client. And I haven't heard any, Judge, we presented at our motion to get some type of limit on or filter process for the discovery in this case. We had empirical data of the number of hits that the elevator video got. We had our IT expert conduct searches, and we gave the court empirical data of how many people were looking at this. The Miami Herald came back and said, oh, we only got 2,000 clicks, when there were millions. Too bad for the Herald, but there were millions nationwide. The state has not presented to this court any empirical data about who's even watching these interviews on court TV. So at this stage, I'm asking the court to deny it, not impose any type of restrictions upon the defense. We think that what we've put out there is a counter-narrative to mischaracterization of the state's discovery that we're not materially prejudicing anyone, any potential jurors. And there's no substantial likelihood of that. The substantial likelihood already occurred when the state just dropped every piece of evidence out there, whether admissible or not, for the consuming media, the media to consume it and digest it and then spin it however they want. We have to push back, and I think the case law supports that the court take no action at this time.
And we're doing it consistently with the First Amendment.
Judge, may I reply?
Yes, briefly.
Yes. Counsel's last words were, we are obligated to put out a counter-narrative. The premise of that statement is, I want to try this in the court of public opinion. To put out a counter-narrative, there must be an original narrative. And to put out a counter-narrative against the state, which is done in a trial, it's in court. The state has not put out any narrative. The state just produces evidence. We do not release statements. We speak in court. A person obtaining any sort of evidence, such as autopsy photos, and mischaracterizing that autopsy photo is their right as a citizen in Florida, period. We cannot control how people misperceive things. We cannot control how people misdirect things. Neither can counsel to his point, and we can see that. But again, no one from the state is trying to try this in the court of public opinion, and the defendant is trying, more specifically the respondent, is trying to taint the panel before it gets here. That's the particular problem. People without credibility on the internet making wild accusations, wild statements on both sides, because it's not only against the respondent and the defendant. Have no case.
By our reputations in defending our client.
And unless there's data or evidence to support it, it cannot surpass the First Amendment right. Any
Can err and say whatever they want. That's their problem. But the litigants have no.
The First Amendment has a very high standard, and the state has not shown any evidence to support that speaking to the media will affect the jury pool. Your Honor even said, if this docuseries, we don't know. And unless there's data or evidence to support it, it cannot surpass the First Amendment right.
And Judge, we are, it's on the record, Ms. Pugliese and I said it last in the court, we are not filing, if the state's concern is we're trying to try this in the wake of we are not filing a speedy demand. It's on the record. I stand by that. Ms. Pugliese stands by it, and we stand by our reputations in defending our client.
Judge, I have one last comment, and it actually goes to a further request from the state. So, as counsel had mentioned, the fact of they had to put their narrative on, say, the elevator video. What the attorneys say, and we all know this, what the attorneys say in trial is not evidence. That specific narrative would have to come from his client if she so chooses to testify in a trial. The reality is this is where we run into problems with these interviews for this TMZ program. Now, obviously, Your Honor may not have jurisdiction over TMZ, but Your Honor does have jurisdiction over the parties here. My understanding is you have to give permission to publish anybody's statement in any of these documentaries, and I believe Your Honor could put in an order to ask and order the defense to not authorize TMZ to post their statements in that, that documentary. And I think that is the appropriate remedy here.
The court could order the parties to revoke their release, their press release, their release for their news.
Kinds of responses.
So, what do you guys think so far? Do you think that they should be allowed to do that documentary with TMZ? Here's my opinion. I think they should let them, but they can't talk about any of the evidence of the case, maybe. You know what I'm saying? Well, that could get tricky, though, because then that means they're not even going by evidence. That'd be opinions, and then it would be based on not factual, or like not evidence. That's tricky, yeah. So they don't want to bring in the evidence, but I guess if they do release discovery, and the public has a lot of that, why couldn't they talk about that? I don't know. That's tricky. What do you guys think? I mean, I would say no. Because here's the thing, they're talking about how it's unfair because the media is portraying it one way, but that's the way it goes with cases. Like, you can't control the media. So it's just the way it happens, and it sucks, but it's, I mean, okay, this is me editing the next morning or the next afternoon. First of all, I want to say a couple things. So first of all, I just want to tell you, I am extremely tired watching this, because when I'm recording this, where I'm watching this on camera that you guys have been watching, this was like 4:35 in the morning up till 6 in the morning. I hadn't slept yet. I was extremely tired. You could probably tell, so I just wanted to make a little disclaimer there. That is me being up all night, working all night, extremely tired, but still able to absorb what's going on, but just like my eyes get tired. Okay. So with that being said, I want to clear up, as I'm going through editing in this, I'm like, wait, this could be misunderstood. So when I'm talking right now about the media, like, oh, the media, you can't control the media, you can't control what they're doing. I'm talking about the defense can't control what the media is doing, and the fact that they want to push back in the media and in the public. That's not the defense's job to do that, because the state isn't doing that. All the state's doing is releasing the copies. They're not doing interviews and stuff. They're just releasing the interviews, the body cams, the discovery, the files that they legally have to, because they're a sunshine state. They legally have to release it to the public. It's just the way that our system works, right? The public has a right to see what's going on, you know? So when I'm talking about they can't control the media, and I'm talking about the defense can't control the media. It's not the defense's job to push back right now. They'll get their chance in the trial. The state's not going on trying to, give their side and fight the case. So the fact that the defense keeps saying that, like, well, we have to. No, they don't. They can't control what the public thinks or what the media thinks. If they're thinking something against the client, they have no control over that. They have to do it in the trial. They fight the case in the trial. They can't do anything about how the public sees the case and stuff. It sucks for them, yeah, but what can they do? The state's not doing anything. They're just doing their job. They're not doing interviews. They're not fighting it in the public. They're just releasing the discovery files that the public legally has a right to, okay? But I just wanted to make sure when you guys hear me talking about it, I am referring, when I'm saying that they can't control, I'm talking about how the defense wants to try to control the media or be able to push back. That's what I'm talking about, okay? So I just wanted to clear that up. Now I'll continue my rant from last night, or my thoughts from last night, but just so you kind of know what I'm referring to, because in my head I know what I'm talking about, but I could see listening to it, you might be confused and think I'm saying something else. So having my channel on true crime, I mean, we see it a lot where there is a lot of stuff going on in the media and different opinions and stuff, and the lawyers just have to, be professional and just wait for the trial and try to fight it in the trial. It's like they can't really do too much as far as, what the public is saying, and the public, being able to request certain files, that are allowed in whatever county that it's in. If they're allowed legally, they can't really control that, what the media does with those and what they say and what their opinions are. And so the lawyers are supposed to just kind of be professional and wait for the trial, right? So actually, no, I don't think they should. Like, the fact that he's like, talking about, I have to push back. No, he doesn't have to push back, because the state's not out there pushing back. All they're doing is doing their job, releasing files that are allowed to be released. What they really have to release, actually, because they're a sunshine state, they have to. They have to be transparent. They have to release things. So it's just the way it is. So they're not sitting there doing interviews trying to push a narrative. So the fact that he's like arguing like, well, I have to push back. I have to push back. No, you push back in the trial. You know what I'm saying? You're not a part of the media, so you don't have to push back on the media. That's unprofessional. That's not your place. You push back in the trials when you push back. So that makes no sense. The more like I'm talking it out and listening to it, because it's like probably the third or fourth time I listened to it, because I was trying to pick out highlights. And at first I was like, yeah, I see their side. I saw both sides. But now, as I'm thinking and talking it out, I don't see his side. He's not the media. He doesn't need to push back in the media. The freaking state aren't the ones pushing in the media. It's the media. It's us. I'm a part of the media. It's us discussing the case and giving our opinions, with the files that we legally have the right to, and we're discussing them. And maybe there's certain media maybe that, I don't know. No, we're all freedom of speech. We're allowed to have our opinions, right? So it's not the lawyer's job to push back. It's not his job to fight the media. It's his job to fight it in court. So no, I don't see their side anymore as far as the defense right now on this issue. No. They should, no. I see it in like a personal way, in like a way like personally, like, yeah, you should be able to fight. But no, their time to fight back is in the trial. Then they'll get to fight back. Yeah. Okay. Anyway.
Judge, I want to caution the state, or if you can caution the state, part of what we're seeking is disclosure by the state of what we consider to be either attorney-client or work product communications.
Part of what you're seeking?
Yes, because the state is in possession of our private communications. If the state is going to be filing any kinds of responses attaching these communications, again, they're letting the toothpaste out of the tube. It needs to be filed under seal.
Just don't attach it.
Judge, we've also made a lot of these communications available to defense. It's over a terabyte of information. We will have to work with defense and communicate to get a device from them to be able to put all of these on. That being said, we're going to tell our public records people to not release without further order from you regarding the
privileged information, yes.
Correct.
Yes, Judge. So that's going to be part of the litigation, is whether voluntary disclosures to third parties are privileged for client conversations.
Or work product.
Again, voluntary.
We'll wait for your order.
Okay, so Tuesday I'm going to respond to this. If you could, I'm going to look for a copy of your motion. If you could reply by next Tuesday, does that give you enough time?
Next Tuesday is in the coming Tuesday?
Yeah. My concern is that you seem to have some urgency here about obviously the non-disclosure of what you consider privileged.
Right, Judge, because we don't know how the filter team was. Are we going to need to move to recuse the entire state attorney's office for not following proper protocol, for searching into communications that are privileged? There's a lot of issues here, but I really want to know, because Mr. Preto and I were named as principals in their warrant. Are we being recorded, our conversations? Can they at least answer that today?
Okay, so that's the urgency of what...
Judge, there are no wiretaps. These were pursuant to 2 warrants that we've provided counsel and are part of the public record.
And can we also make it clear, since the media is listening, that this is not a tampering case? There's no allegation, at this time at least, there's no allegation that anything was done to this computer to tamper with it.
We only recovered the laptop on Tuesday that should have never been in the defendant's possession to begin with.
That's not
true.
All right, so here's what we're going to do. It sounds like you need more time to respond to that. They have given you their assurances that you're not being recorded right now, which takes away that urgency.
Or any warrants being served on our iCloud accounts or any of our personal communication devices.
There have been no warrants served on anything regarding Mr. Preto or Ms. Cavusi. The warrants have been served regarding Ms. Clenny's iCloud, Ms. Deborah Clenny's iCloud, Mr. Clenny's iCloud that was kind of commingled with Ms. Clenny's iCloud. That was served in November. we don't have any of those matters pending. There will be upcoming warrants on both of Mr. and Mrs. Clenny's iPhones. There is an upcoming warrant on Mr. Ogunselli's laptop as well.
Right, but not for counsel.
Well,
We have not sought any warrants or process on council's.
The problem is there are work product, attorney-client communications on their phones with a group chat.
So that's, again, voluntary disclosure to third parties.
We're not litigating that issue now. You can, the state can respond and we'll argue with.
For that, I'm going to give you 2 weeks to respond to that. If there's some sort of emergency that comes up, or you believe that there's an emergency where you believe that something is going to be disclosed that you believe is privileged, come and bring it to my attention. I'm going to put it on the state to do the same. If you know that something is going to potentially be an issue, you got to bring it to my attention. But right now, I'm going to give you 2 weeks to respond to that. That doesn't take away the fact that I'm going to have this order for you on Tuesday.
And lastly, Judge, related to that is we'll be doing a motion to quash a subpoena. It was filed against our defense expert, and it's set for, or his interview with Ms. Hogue is set for the 9th, which is next week. So we'll be in the process.
Tuesday as well?
Yes, Judge, we'll have that filed. I just wanted, because I know we may not hear it, but until that gets done, we would move to, hold off on any kind of interview. He is being represented by Jude Fecciadomo, so, but we believe, because it's our defense expert, that it's us who would be doing the motion to quash. So,
just get it filed before the 9th, and,
No, the 9th is the
it's the day he's supposed to go.
for the subpoena.
He's supposed to go.
Okay, so if that happens, obviously you need to hold off on anything if there's a pending motion to quash.
Yes, sir.
Okay, that's the end of this video. Let me know your thoughts on what you think about some of the topics discussed. As far as, do you think you should be allowed to do the TMZ documentary, the lawyers, if they should be allowed to have their interviews and stuff, like where they talk in the documentary? And also, what do you think about her parents being arrested? So like the lawyer said, I do think it was kind of crappy that TMZ reported that it was tampering with evidence type stuff charge, and it wasn't. Now, like they said, they're still looking through the computer, so it could still be that charge if they find that there was tampering with evidence. If they find that they added or deleted anything on that computer, then yes, they could add it. But the charge that they were charged with was not that. It was just getting into somebody's computer without authorization, which is a third-degree felony. And I think there's still people that are misreporting it, saying that it's evidentiary tampering and stuff because of the false reporting, I guess you would call it, because TMZ reporting it falsely and then everybody else reporting it the same way after after TMZ reported it, and they're all following the lead, So yeah. Just to clear that up, that's not the charge right now. There's no proof of that yet. They'll find out when they go through the computer. So I personally don't think that they did tamper. Like, I don't think that they added or deleted anything, in my opinion. I mean, I could be wrong, and I think a lot of you guys disagree, and a lot of you guys do think that they did. I don't know why. I just don't think that they did. Well, if anybody did, it would be Kim. And if it happened, I feel like it would have been Kim that did it before he turned it in. So remember when he said, oh, I went on it, really didn't open anything, and then we did the FaceTime. But I think he did look through it. I do think there's a good chance he did look through more than what he's saying, and possibly maybe deleted something. I don't think he added anything. I don't see that. But I could see maybe deleting something to make, if there's something that looked bad against Courtney. But I almost don't think, like I said, I do think he probably went through it, but I don't think he deleted anything, because why do I think there probably wasn't anything on there to delete? When I say that, I mean as far as anything on there that would be important enough for the case or something that they would want to delete is what I'm saying. Not that there's nothing on the computer. But just my opinion. Like I said, from the comments on my last live about it, I do feel like a lot of you guys probably are going to disagree with me on that one. And I also don't think that he, was trying to get money. Like, he was messing with the cryptocurrency type thing. I don't think that's what he was looking for. I really don't. He has money from Courtney and stuff. And, I feel like it looked like he probably did well in his life, too. It's not like he necessarily needed money. So, would he risk committing a crime? And I know he ended up committing a crime, but I don't think he realized what it was. You know what I'm saying? Let me reword that. I don't think he thought he would get caught. I think he realized what he was doing was wrong when he was getting into his computer, into Christian's computer, but I don't think he thought that he would end up getting caught, probably because, you know, the lawyers are aware of it. They're kind of helping him and a part of the process. So that's what I mean by that. But as far as him taking money, I mean, I don't know. I don't think I mean, for him to, it's not like he was desperate for money. So for him to risk getting charged for that, because there's no way he was going to get away with stealing money from, you know what I'm saying, when the eyes are on the case. So yeah, that's what I mean. And plus, it wouldn't be probably worth the risk for them. What they were doing, like I said, I'm sure he realized that there's potentially he could get in trouble because they were being kind of sneaky about it. But for them, they're looking at, okay, this is my daughter's life, prison. So to them, it was like probably worth taking that risk to see if there's anything that could help or hurt her case on the computer. But as far as them stealing money, that's not going to help the case. It would only hurt the case if they would get caught. So the risk, why would they even risk that? They're just trying to save their daughter's life. You know what I'm saying? They're just trying to win the case and trying to get anything to win the case. They're not trying to steal money because it's not going to help with the case, and they have money. You know what I'm saying? So it wouldn't be worth that risk to commit a crime doing that when that's not what they need. That's not worth it to them. In my opinion, what was worth committing a crime is trying to help save their daughter. I'm not saying it's right. I'm saying, like, in their eyes, they're not going to sit there and, let's steal his money. They don't need the money. If anything, that would just hurt them trying to free their daughter. Do you see what I'm saying? This is why I don't think that they would risk that. It wouldn't be worth them to risk, let's try to steal the money. They don't need the money, you know? It's not like they're, like, hurting for money at this point, at least. So, look at this. Like, my skin just gets, I don't know what happened. I don't remember scratching myself or the last recording, which was, just a few minutes ago. I didn't have it. I don't remember scratching myself or anything. They just appeared. I mean, maybe I itched, but I mean, not like I scratched where it's like these red marks. Weird. I get that. And then it'll go away. You know what I'm saying? Like 20 minutes, it'll probably be away. Weird. But like, obviously, if he ends up going in and stealing money like that, I mean, there's no way he's that stupid to think he was going to get away with that. I just don't think that was on his mind. I think he was more trying to get evidence or delete evidence that would help his daughter's case. I do think the intent was to see if there was anything on there that could help her, I'm thinking. But I do think, you know, if they did find something on there, I don't think the lawyers would have been stupid enough to delete anything. But I don't know if I trust Kim to have not looked through the computer. And if he did find something that made his daughter look bad, that he wouldn't have deleted it. But I don't think there probably was anything on there that he found for some reason. I don't know why. I mean, that's just my opinion and what I'm thinking, but we'll see what they find. I could be wrong, and I'll admit it if, you know, they find something different. But yeah, love to hear your guys' thoughts. I love reading your guys' comments, so let me know your thoughts, and don't forget to like the video. I never ask. I always seem so, it's not my, like, in my comfort zone to be like, hey, like and subscribe like most YouTubers do. It feels so weird, but yeah, though, if you like it, like it up. I can't even say it like natural. It sounds so stupid. But if you're not subscribed already, go ahead and subscribe. Smash that subscribe, or what do they say, like, smash that button or whatever. But yeah, seriously though, check to see if you're subscribed, because I know there'll be channels that I watch all the time that I love and I just forget to subscribe. You know what I'm saying? I don't know. I just like watch them. So a lot of the times I think people just don't realize they're not subscribed. So yeah. All right, guys. Have a good weekend. Bye. Oh, let me know if there's any like new cases. I'm looking for a new case that's current that we could kind of dig into and deep dive. When I mean current, I mean within the last maybe 5 months. Let's limit to that. Because a lot of times when I ask for recommendations, a lot of you guys give me old cases, which is fine. You know, we could go over old cases, but right now I want to try to find like a more current one to add to my roster or whatever you call it, to add to the cases I'm already covering. Yeah, so maybe one like in the last 6 months, let's say. All right, guys, bye. Have a good one. Thanks for watching. Bye.